There you go. Welcome, everyone. I'd like to call the Thursday, January 18th, 2024 meeting of the Planning and Zoning Commission. If we could please keep our voices down in the back there. Appreciate it. Present tonight, Sean Morgan, myself, Carol Snow, Chair, Mike Bugda. Do we need a microphone?
Just in case.
Okay. Bob O'Connor, Jeff Downs, our town planner, Aaron Mannix, and online we have attending John Dusa and Vice Chair Bob Reinhardt. We're expecting Janet Peckinpah to join us momentarily, so that's the team. Our first agenda item tonight is a discussion of 21-03 plus CSP. That's 856 Boston Post Road, map 39, lot 8, R2 district. Owner Faith Whitehead, applicant 856 Boston Post Road LLC, special exception permit application to construct a single family residential cluster development and associated site improvements, as well as a coastal site plan review. So this is just the very start of our discussion of the record as it relates to a remand about an appeal. And therefore, I would like to take about 10 minutes to give a little background information to everyone and get everybody up to speed. So I'm going to begin with a very brief timeline that goes from 2021 to 2024. In February 19th, 2021, applications were received for special exception permit application filed by the applicant and owner Faith Whitehead, 856 Boston Post Road LLC, and a municipal coastal site plan review application prepared by Michael J. Ott, Summerhill, and civil engineers and land surveyors for the applicant and owner Faith Whitehead and 856 Boston Post Road LLC. These were filed with the Town of Madison Planning and Zoning Department. On March 18th, 2021, the first public hearing was held for this application. On May 20th, 2021, the second public hearing was held. On June 3rd, 2021, a third public hearing was held. And on June 17th, 2021, the commission moved to deliberations and approved both the special exception and coastal site plan review applications. In 2022, on August 12th, 2022, an appeal was filed to New Haven Superior Court. In 2023, we received the judge's memorandum of decision. It was issued on July 21st, 2023. As far as planning and zoning goes, we then had a special meeting for an executive session with our attorney on August 17th, 2023. On September 25th, 2023, our attorney filed a motion for clarification to the judge. On October 10th, 2023, we had another special meeting and executive session with our attorneys, Peter Gelderman and Ira Bloom. On November 24th, 2023, we received the judge's order regarding the motion for clarification, stating that the substantive terms of the court's remand are clear. I'll go into this more in a little more detail because I'm going to give more information because many of us haven't received that even among ourselves, since we're not really allowed to do any communication between meetings. So in 2024, we had another special meeting and executive session with our attorneys, Peter Gelderman and Ira Bloom, on January 4th. And that brings us up to today, January 18th, which is our first opportunity for the commission to discuss this among ourselves, really. Okay. Oh, and I also want to just point out that this is a public meeting, not a public hearing, so there won't be any involvement from you all. Just have to say listen to us. Okay, so I'd like to give some background information about the remand by starting with the July 21st, 2023 memorandum of decision. I'm not going to read all 8 pages or whatever it was, but I'm just going to give excerpts that relate to us and what we're tasked and what the responsibility is, what we're tasked to do. So under general statutes 8.8, it empowers a court to, after holding a hearing on the matter, reverse or affirm wholly or partly, or may revise, modify, or remand the decision from which the appeal was taken in a manner consistent with the evidence before it. The court therefore remands this matter and directs the commission to review the existing voluminous record before it and perform its duty of considering the effects of the proposed septic system on coastal resources. Accordingly, the commission should look to the evidence in the existing record regarding the impact of the proposed septic system on coastal resources to inform its decision in engaging in the single review process on whether to approve or deny both the special exception permit and the coastal site plan. The court further directs that the commission shall not reopen the hearing to take additional evidence. The commission is directed only to consider the existing evidence in the record regarding the potential effects of the proposed septic system on the coastal resources, as they are required to do under the CAM Act as well as the Madison zoning regulations. Then I wanted to read a little more text from the order regarding the motion for clarification, which we received November 24th, 2023. This is again quoting, "This court's decision is clear. However, the court grants the defendant's motion in order to make its decision crystal clear and to ensure that its remand is properly effectuated. More importantly, the parties shall be mindful that this court's decision is not intended to give them an opportunity to present new evidence or for the commission to engage in new fact finding. In addition, the parties shall be mindful that a motion for clarification may not be used to modify, limit, or to alter the substantive terms of a prior judgment. The substantive terms of the court's remand are clear. The commission should look to the evidence in the existing record regarding the impact of the proposed septic system on coastal resources to inform its decision in engaging in the single review process on whether to approve or deny both the special exception permit and the coastal site plan. The court further directs that the commission shall not reopen the hearing to take additional evidence. The commission is directed only to consider the existing evidence in the record regarding the potential effects of the proposed septic system on the coastal resources, as they are required to do under the CAM Act as well as the Madison zoning regulations." Again, the court's words are clear. We should look to the evidence in the existing record regarding the impact of the proposed septic system on coastal resources to inform the commission's decision regarding whether to approve both the special exception permit and the coastal site plan. As such, the court's remand includes both the special exception permit and coastal site plan. I want to say that reviewing the evidence in the existing record has been overwhelming and not an easy task. The voluminous record for this application and case include 177 documents in the application materials on file on the Madison Town website, 215 items in the court records, 30 pages of meeting minutes of the public hearings and deliberations, 446 pages of meeting transcripts of the public hearings and deliberations, 14 and a half hours of YouTube videos of the public hearings and deliberations. In addition, we reviewed state statutes, local regulations, and land use case laws, including the 1971 Connecticut Environmental Protection Act, the 1979 Connecticut Coastal Management Act, Madison zoning regulations for small cluster developments effective 10/25/19, Madison zoning special exception permit regulations effective 12/1/10, Madison zoning coastal zone regulations effective 12/1/10, the 2013 Madison Plan of Conservation and Development, and the 2023 Connecticut Land Use Law for Municipal Land Use Agencies, Boards, and Commissions. I also want to read out loud to everyone, since I haven't been able to share this any other way, the responsibilities of the Madison Planning and Zoning Commission. Everyone can hear me okay? Thanks. The Madison Planning and Zoning Commission understands that we are responsible for considering the wider context and implications of the impact of land use applications to protect public health and well-being of our community and our natural resources. According to Madison zoning regulations, section 3.4, the following use is permitted by special exception for small single-family cluster development subject to the criteria set forth in section 3.12, which states in section 3.12.I, the maximum number of attached units, no more than 2 units may be attached together. This limitation shall not apply to adaptive reuse of existing buildings, provided the floor area of any such building is expanded by not more than 15%. According to Madison zoning regulations, section 4.4.2, all special exception permits may be granted subject to conditions and safeguards required to preserve public health, safety, convenience, welfare, and the property values of surrounding areas. Additionally, the site is within the downtown village district, according to Madison zoning regulations, section 30.2. The purpose of this section of the regulations is to protect the distinctive character, landscape, and historic structures within the downtown village district in accordance with the goals set forth in the Madison Plan of Conservation and Development. Under CGS 8-2, we are responsible for protecting historic, tribal, cultural, and environmental resources and providing adequate provision for public requirements, including sewerage and protection of water supplies. Section 22A-15 of the Connecticut Environmental Protection Act states as its purpose to create a public trust in the air, water, and other natural resources of the state of Connecticut, and that each person is entitled to that protection, preservation, and enhancement. And it is in the public interest to provide all persons with adequate remedy to protect the air, water, and other natural resources from pollution, impairment, or destruction. For a coastal site plan review, we are obligated under the 1979 Coastal Area Management Act, Section 22A-92, to ensure the development is consistent with the rights of private property owners and the capability of the land and water resources to support development, preservation, or use without significantly disrupting either the natural environment or sound economic growth. To preserve and enhance coastal resources, to consider impacts of sea level rise, coastal flooding, and erosion patterns and methods to mitigate adverse effects on coastal resources, and to determine whether potential adverse impacts on both coastal resources and future water-dependent development activities are acceptable. These responsibilities are further described in Madison Zoning Regulations, Section 25, Coastal Zone Regulations, Section 25.3.4. In determining the acceptability of potential adverse impacts of proposed activity on both coastal resources and future water-dependent development, the Commission shall, 1, consider the characteristics of the site, including the location and condition of any of the coastal resources defined in CGS 22A-93. 2, consider the potential effects, both beneficial and adverse, of the proposed activity on coastal resources and future water-dependent development opportunities. And 3, follow all applicable goals and policies stated in CGS 22A-92 and identify any conflicts between the proposed activity and any goal or policy. That's a kind of quick summary, but it gets us started, I think, for our discussion. I want to just reach out to John Duza and Bob Reinhardt, who are attending by Zoom, to see, and as well as the other commissioners, to see if any at this point.
I'm sorry, Carol. I heard everything clearly until the very last sentence you said.
Are we good? Is what I just said. I don't know if that was
Except for that very last sentence, yes.
Carolyn, what happens next?
So what I thought we would do is review the application process chronologically. That makes the most sense to me. And as I said, this is the first time we've had a chance to discuss it. So it's going back really to the first public hearing, or even actually going back to the applications themselves. So I thought I'd get the conversation started. Erin, is there anything else you wanted to add?
Just wanted to let you know that Janet
Welcome, Janet.
has joined.
We'll do it. I won't repeat what I've already just read. But you can watch it. You can watch it or read it later. Okay, so I'm going to start by just describing the applications and taking a close look at those. 21-03 plus the coastal site plan and 856 Boston Post Road. It was a special exception permit application to construct a single-family residential cluster development and associated site improvements, also a coastal site plan review. And I can refer to what exhibits in the court records these different points that I'm making are, but I think that, I don't know, we'll see if that's important or not. But I'm happy to provide that information. So this application, by the way, is exhibit 001B. Throughout the process, the agendas, minutes, transcripts, and approval letter represent that the special exception permit application is to construct a single-family residential cluster development and associated site improvements, when in fact it is an application for a multi-family cluster development with 3 duplexes, one of which is an adaptive reuse of a historic structure, and so doesn't really count or isn't qualified. And but also with an additional single-family unit for a total of 7 residences for units on 1.81 acre, which is 78,844 square feet. In the downtown village district, the property is currently zoned R2, which allows 1 residence per 40,000 square feet. So the special exception permit application exceeds the allowable density for small cluster developments by 1 duplex as per the Madison zoning regulations section 3.12.I. And this density impacts the septic issues substantially. Then turning to the coastal site plan application, the applicant's engineer, Michael Ott, Summerhill Civil Engineers, prepared and signed the application form, which is exhibit 00B. Engineer Ott checked the not applicable box for tidal wetlands in section 3, part 3, identification of applicable coastal resources and coastal resource policies, indicating that the site is not adjacent to tidal wetlands. The site is in fact within 1,000 feet of a tidal wetland as defined in CGS 22A-29.2. It is approximately 500 feet from the Fence Creek Salt Marsh. This misrepresentation of the site's proximity to tidal wetlands impacts septic issues substantially. On March 18th, 2021, the tidal wetlands misinformation is repeated in the statement from the Department of Emergency Environmental Protection, DEEP, in Exhibit 079, in which Marcy Balint, Deep Senior Coastal Planner, Land and Water Resources Division, states that the site is located outside any 100-year flood zone for NFIP FEMA's Map Service Center mapping, is not waterfront nor adjacent to coastal resources such as tidal wetlands. DEEP chose not to respond to the application for reasons not stated, but this is a substantial omission in the review process of the application, as we rely a lot on DEEP's response to applications. Does anyone have anything they'd like to add at this point? I'm just getting started.
No.
And I don't know how long we'll
Go
last tonight because we have a lot of other things on the agenda, but I don't know if we want to set a time limit. Aaron, your thoughts or anyone else's thoughts? Okay, we'll see how it goes. All right, and John and Janet and Bob, if you have anything to add to what I'm saying, please chime in. Thank
Will
you.
do.
I think you're off to a good start.
Thanks, John. On March 18th, 2021, the first public hearing was held. And during that first public hearing, the applicant's engineer, Michael Ott, gave a relatively brief summary of the proposed septic system and spent considerably more time describing the stormwater runoff. Though septic systems are affected by stormwater runoff, they are separate systems. By the way, in case you can't, we're focusing just on septic as per the directions from the judge. Later in the meeting, the attorney for the applicant, Christopher McKeon, told the commissioners, septic not within your purview has to be dealt with through the Madison Health Department and the State of Connecticut Department of Health. If we can't satisfy the Department of Health or the State Department of Health, we can't get a building permit and we can't build a project. It is not an issue for planning and zoning. That's from Exhibit 194, page 75. Variations of this statement were repeated throughout the public hearings and into the deliberations and gave the commissioners the impression that septic issues were not within their purview. In fact, they need to be addressed when the commission decides whether to approve or deny a special exception application and coastal site plan review. That attorney's advice was confusing and a substantial factor regarding the commission's decision to approve the application. Anyone want to add anything else about the first public hearing? We might get pretty far that side.
No, don't keep going.
On May 20th, 2021, on the afternoon prior to the second public hearing, the applicant's attorney, Christopher McKeon, sent then Madison Director of Planning and Economic Development, David Anderson, an email with 5 potential conditions of approval. Just to quickly summarize them. 1 was about blasting, 2, stormwater management, 3, organic pesticides, 4, ACA approval, and 5, maintenance of the historic ledges, residence, and historic stone walls. That's exhibit 179 in the court records. Attorney McKeon omitted a condition about septic approval by local or state health departments, which appears in many other special exceptions in the Madison zoning regulations. And I'm going to read the language that many of those special exceptions includes. Quote, sewage disposal systems shall meet all state and local requirements, shall be specifically approved by the local officer, and shall have no adverse effects on adjacent sewage disposal systems. Said sewage disposal systems shall be located so as to allow an equivalent amount of suitable space on the lot equal in size to the systems to be installed, which space shall be held in reserve and used for the installation of a completely new system, should such a system be required in the future. Therefore, state and or local health department's approval of the proposed septic system is not among the conditions for this application and could be considered a substantial omission. At the second public hearing, attorney Christopher McKeon and engineer Michael Ott quickly run through the septic design that he neglected to do in his presentation at the first public hearing, to which Mr. Ott replies, I apologize, I completely forgot. That's from exhibit 195, page 47. Mr. Ott proceeds to present another relatively brief summary of the septic proposal, in which he describes phone communications he had with the state health department, confirming that the septic issues are the responsibility of the local health department. He provided no supporting documentation of those phone calls. His presentation lacks supporting documentation from the state health department and the Madison Health Department, and thus did not fully resolve the confusion over which health department would be responsible for approval of his proposed septic system. Anyone else have anything to add? Okay. So going on to, let's see, the third public hearing on June 3rd, 2021. Immediately prior to the third public hearing on June 3rd, 2021, engineer Michael Ott sent attorney Christopher McKeon a one-page email with a summary of his opinions regarding his proposed septic system, again, without providing specificity or any supporting documentation for his opinions. And that's found in exhibit 182 of the court records. On June 3rd, 2021, at the third public hearing, relatively lengthy and very detailed presentations were provided by attorney Keith Ainsworth, the environmental attorney representing the environmental interveners, Jeff Sissel, the licensed professional engineer, and board certified forensic engineer Steve Trinkos, a licensed professional engineer, and George Logan, principal environmental scientist with REMET Ecological Service. They provided substantial information with supporting documentation for Madison residents who have expertise in the potentially harmful impact the proposed septic system will have on the local environment, and who provided better, safer options for septic systems than what the applicant's engineer, Michael Ott, proposed to use. They described various calculations of the flow rates of stormwater and its impact on the proposed septic system, and also highlight the role of the state health department versus the Madison Health Department in approving the proposed septic system. They provide substantial, specific, detailed information on the hazards that the proposed stormwater and septic systems will cause to the Fence Creek tidal marsh and its ecosystem, located approximately 500 feet from the property at 856 Boston Post Road. In Exhibit 196, the transcript for the June 3rd, 2021 meeting, page 66, engineer Steve Trinkos said, with this large of a septic system here at 3,000 gallons per day and multiple systems in an effectively very limited drainage area, which only comes up to the ridge line in this area, you will not meet the depth goal of 10 milligrams per liter at the property line. So you will have nitrogen being discharged through the subsoil following a topography of generally to the east and ultimately to tidal wetlands. I will leave that aspect to be more talked about by George Logan as far as the environmental impact, unquote. Exhibit 196, transcript for June 3rd, 2021, page 79 to 81, wetland scientist George Logan states that, quote, "The septic system effluent that is not fully treated, which is the case at this site, will ultimately end up in the Fence Creek Salt Marsh." It further states, "Through which this layer, the minimally treated nitrogen-rich septic effluent will travel to, again, the sensitive natural resource, which is the salt marsh and the tidal creeks, the Fence Creek Salt Marsh." In Exhibit 196, transcript for June 3rd, 2021, page 163 to 164, Planning and Zoning Commissioner John Mathers states, quote, "While I believe that Mike Ott has designed a septic system that meets the current regulations, I am convinced by the opinions of Dr. Skelly, Mr. Trinkus, Mr. Logan, that those regulations that Mike Ott complied with are likely outdated and obsolete. If there are problems with the septic system, these problems are going to be long-term problems that are going to affect Fence Creek. We know that we are on a shelf here. There may be 40 inches of sandy soil, but underneath that there is rock. Water flows on rock. If that system is not adequately treating the runoff, it is not a gravity-fed system. It is relying on pumps. It is also being influenced by the storm runoff from the driveway, as the applicant has confirmed the driveway is not pitched so that the water will run toward the neighbor. It is pitched so that the water will run toward the lawn. And it is contributing more flow. I'm really concerned about that." Exhibit 196, transcript for June 3rd, 2021, page 161, Attorney Ainsworth adds, "You might have missed the point that the fact that there is an alternative system that could be used that is better, that exists, isn't the application of a regulation that doesn't exist. It is the design of another system that should be approved. Your commission has the ability to do that as a condition under your duty to protect the environment. It is not about whether or not he can design a system that complies with the current health code. It is that he has an alternative that is in the transcript, more protective." On June 17th, 2021, during the deliberations for the special permit application, there was considerable confusion and discussion about whether or not septic issues were within the purview of the Planning and Zoning Commission. And I just want to, as an aside here, say that when we're going through the transcripts, which can be downloaded as PDFs or Word documents, we can do searches. So one of the searches I did obviously was septic. Another I did was purview, and it's translated as purview, like pay-per-view TV. So you have to like navigate very carefully. That wasn't the only example, but I just wanted to use that as some of the challenges we faced going through this huge volume of documents and how to manage, and how to sort of pull out the substantial information that we're looking for. Does anybody have anything else they'd like to add at this point? Okay.
Carol,
Yes.
I think it's, we're talking about the June 3rd meeting, correct?
Yes, yeah.
Okay, so you pretty much captured everything I had pulled out of that. The only other thing I saw, which I thought was interesting, was the presentation from one of the interveners, I forget who it was, stating that they had spoken to the state with respect to a state review of the septic system, and it said that the person they spoke to, the state, thought it would not be unreasonable for a system like this to be provided to the state for their opinion, given that it was kind of on the cusp of being a single residence versus multi-residence. So it was just in opposition to what the applicant said, and in all the subsequent information I looked at, I never saw a resolution to that as to the two different opinions. So I just wanted to bring that up.
Thanks. That's good. Yep. All right.
Carol?
Yes, John.
Thanks. I think the June 3rd transcript adequately answers the questions that the judge raises and assigns to us. So I think, as you cite on page 66 of the transcript, then on page 79, really through page 82, it's substantial, it's specific, and applies exactly to what she's asking us to do. I think that Professor Skelly letter is substantial, but it's not really specific enough to use to answer her question. But again, I think on June 3rd, that testimony on page 66 and 79 through 82 hits all those points.
I agree. Thanks.
Agreed.
And also, just so everyone, for the record, I mean, we do have some engineers, not civic engineers, but engineers, not a few engineers on the commission, but we're lay people. So we're interpreting as best we can what the judge has directed us to do and what is substantial. We've had, as I mentioned, several executive sessions with our attorneys to help us better understand what our directives are and what is considered substantial. One of our takeaways was that it should be very specific. We don't use words like may or might or could, but that it should say will, to be more substantial. And when you're weighing the opinions of one engineer against another engineer, that's important. I think that I mentioned whether or not septic is part of our purview and how that confused people, and it continues to confuse us, I will say. And the obvious question that as a relatively new commission we've all asked was, well, why don't we get the health department permission first before the application comes to us, when that makes sense? But I think that's why in so many cases it was always added as a condition. Or not always added, but it was often added as a condition. And that could have happened with us, and other issues that were added as conditions were not in their purview. So we're sort of weighing out. Obviously we can't get into their heads or know exactly what they were thinking, but you can watch and you can watch the YouTube videos. There was a lot of confusion and discussion about what was and wasn't in the purview of the Planning and Zoning Commission. Is that anything else anyone that wants to add? Okay. Going on to the deliberations on June 17th, 2021. Again, there was considerable confusion and discussion about whether or not septic issues were within the purview of planning and zoning. And I went through and just tracked a few of the commissioners' comments and questions. So from Exhibit 197 transcript on page 4, Commissioner John Mathers asks, are all concerns within our purview? I have great concerns about the septic and the runoff, but we are not the health department. We are the P&Z, and that is really outside of our purview. Does it do harm to the neighbors? That is another thing. That is, does it? It certainly is perceived to be by some of the neighbors, but does it do harm to the neighbors? So I would like to have more discussion on these topics tonight. Is it legal? Is it within our purview? Does it do harm? So Commissioner Mathers requests more discussion about this, which doesn't, as far as I could tell, didn't ever happen. Exhibit 197 transcript for June 17th, 2021, pages 4 to 5. Commissioner James Madison states, there is one area that I'm concerned about and why I will vote probably against it is that I do believe that it does bring harm to that area. Exhibit 197 transcript for June 17th, 2021, page 6, Commissioner Peter Roos states that issues of septic, of blasting, we have got health officials and the experts that can weigh in on how well that is done and how well it is being handled, etc. We've got town officials that do that. I don't think that is our purview. A motion was made to approve the special exception permit application and with the five conditions that were provided on May 21st, 2021, prior to the second public hearing by the applicant's attorney, McKeon, with an additional condition of approval. So I think there was, instead of just 5, it was 6. The owner of the project will be responsible to maintain water service to the adjacent in vicinity properties and will be responsible for all costs associated with the final water facilities plan. Such plan shall be in place prior to the start of any construction activity. But 5 out of the 6 conditions listed are verbatim from Attorney Christopher McKeon's 5/20/21 email sent the afternoon prior to the second of the 3 public hearings. And again, there's no condition regarding the pending septic approval by the State Health Department or the Madison Health Department. Also, I noted that in the above certificate of approval, the vote count was recorded erroneously as unanimously approved 6-3. which I don't know about you all, but it brought to mind, to me, it brought to mind the Harvard Yale game that was a tie 29-21. And Harvard wins 21-29. Anyway, I think that may have just been a clerical error. So not substantive really, but I just want to maybe correct it. And then the vote to approve the coastal site plan application, 6 voted in favor, 1 opposed, and 2 abstained. So that's my review of the voluminous records. I can tell you I spent well over 40 hours going through everything. It's a lot. It's really interesting. It was, because so many of us are relatively new commissioners, I've described it as planning and zoning boot camp. We've learned a lot in the process, and I think now we need to think about what it means, and if anyone else has any further thoughts on what's substantive, what's not substantive, what else we should consider. Yeah.
Well, I have 6 quick observations, and I promise that I will not go on and on. One is this will become relevant, I hope. It's a tale from Newark, New Jersey, and Newark has or had a reservoir which was pristine. There was no property abutting the reservoir. It was one of the last pristine places in Newark. And there was a proposal to build a 30-story tower that would abut the reservoir. The construction engineers said, this is a great idea. It would help the tax base of Newark and would bring in money, and we can engineer it. One of the things I like about my engineering friends, including you, Bob, is that, they're problem solvers. They're, give us a challenge and we'll do it. Now, there's another group of engineers, the environmental engineers. And these folks, when that proposal went forward, were apoplectic. They said, you've got to be crazy. You're going to bring all these people and 30 stories in the car and so and so. And eventually, there's going to be problems. There will be problems eventually. So we can approve this. So anyway, that's one observation. A second observation is John Guskowski, a consultant for the plaintiff, basically said, look, this application checks all the boxes. But he also said at the end of his presentation that, look, the job of and I think this relates to some of your comments, the job of the commission is to go beyond that and to say, is it beneficial for our town of Madison, which we love, to approve this or not approve it for 30 years from now? What will township citizens look and say, as a wise decision or not? Should they have done it? Okay. So a third observation relates with the damage to neighbors. You can say there's a case earlier this year before this commission of a Madison citizen came before us. There was a proposal, not from this guy who opposed it, to build a elementary school. It was a construction permit. And he said, look, my home is very close to this school. I bought it to be in a neighborhood that would be quiet. We're not have buses, children, and this is going to ruin the reason I bought this. So you guys should approve it, should stop this school. They can put it somewhere else. Our commission voted 9-0 to approve the school because our opinion, I think I can speak for you guys, was that in the long run, it was beneficial to the town of Madison to build that school. So are there damage to neighborhoods here, to the neighbors? The neighbors would certainly contend yes. One of them, in fact, many years ago, paid $350,000 to try to avoid having what happened, the type of proposal that we got. So they clearly felt then that they wanted this neighborhood to maintain its character without a cluster development of this type. Again, from my case of the building a school, I don't think this is the last word. Neighbors do not have a veto over what should be built, and they should not. But it certainly is a consideration. Fourth is the coastal impacts in a fragile area. I'm not an engineer. I would note that I found Skelly's testimony very compelling. He testified not as a hired consultant. And by the way, I have nothing against hired consultants. I've done it myself. But he was doing this as a citizen and as an expert in this area, saying, there are significant risks with this. Okay, fifth, I really am getting done here. It's interesting. What I do for a living is I'm a program officer at the National Science Foundation, and we have panels, and the panels make recommendations. But what they do is at the end of it, they produce a consensus document which explains their reasoning. The commission doesn't do that. So if I look to try to say, gee, which commissioner should I try to channel now in deciding what we should do? It was a split decision with strong arguments on both sides. But there's I listened to 9 separate opinions. Yes, there were overlap with some of them, but still there were 9 separate opinions. And I'm not saying that they're all valid, but and honest as far as I know. So finally, in thinking about what to do next with this, there is a slippery slope argument that if we approve this because they check the boxes, we have to approve the pot dispensary next to the high school because it would be good for business in Madison. I'm not fond of slippery slope arguments. I think that's bull. That would not be compelling to me. So there are some observations. I don't know if I spent 40 hours, probably not. I have a job, but I did spend at least a day and a half mulling through and listening to all the tapes. So those are my observations.
Thanks, Bob.
I hope I'm tending to be constructive, really.
I think we do need to stay focused on the septic issues, and your analogies are good ones, but
Well, they
needs-
are septic because it's a question of what you can engineer or not.
yeah, right. Thanks. Anyone else? Thoughts, comments?
So I have a question. I missed the last executive session. I'm not exactly clear on what remand process, what do we actually have to, what's our next step with the board?
That's
Are we-
a really good question. And as I understand it, we reach a decision among ourselves of what we think should be done regarding the 2 applications with supporting evidence or supporting information of why we're making these decisions. Then it goes back to the judge. So we don't ultimately decide. It goes back to the judge, and the judge will then make a final decision. Let's hope it's not too back to us. Aaron, does that sound like that's the next step for the commission to reach some conclusions, decisions, support it with evidence and documentation, and then send it back to the judge?
Yeah, make your findings in response to the remand and give that to your attorney.
Janet, any comments, thoughts?
No, I'm good, Carol. I like everyone's points, and I think that we've discussed this a lot, or we've all thought about this a lot. And I think, yeah, we're good discussing it among ourselves and then sending it back to the judge and, voting on what we're going to send to the judge.
thanks. John Juza?
Oh, Carol, well, I think that we just need to be very careful to be very focused on the question that she asked us from the remand, right? And also, she specifically said, we're not reopening the meeting. We're not taking into consideration other evidence. We could only use what's in the record. So that's all we've got. And her question is very specific and narrow. And I think, especially based on all the analysis that you've laid out, that we're ready to proceed.
Okay, thanks. Bob Reinhardt, anything else?
Yeah, so I spent almost as much time as you, and I think your assessment of the record is very concise and helpful. I agree with John. We have to be very focused on the specific request made to us, which is the septic system. When you read through everything, for me, there were more questions created than facts available because there wasn't a lot of discussion about the septic system itself. But I think it was the third meeting. There was a significant amount of data provided to help us understand what the potential impact of the current design is. So I think I've had enough time to look at everything. I look forward to the discussion. If there's anyone.
Also, Bob, along those lines, I think you're right. It does raise a lot of questions. And the hearings and the meetings obviously would have been different if everybody could have foreseen that this would have happened. But the judge is telling us specifically, you can only use what is in the record.
Yeah, and that's the hardest part. I have lots of questions I'd love to get answers to, but that's not what we have. We have what we have. So that's where we have to hold it.
Yeah, actually, it kind of amazed me that I got through that so quickly when it took me so many hours to do all the reviewing. And I'm kind of like, wait, is this happening so
It's
quickly?
probably permanent brain damage as a result of.
Well, no, it was, I mean, it's all very interesting and, I think none of us really knows why the judge remanded it as opposed to just making a decision herself. And it's somewhat unprecedented, as we've been told by our attorneys, to have this situation. So, and also to have it be virtually a different commission than the commission that went through the public hearings and made the decisions. I was on the commission at the time, but I was an alternate and I was not seated. So I watched from the sidelines while it was happening, which it's interesting that having been there and made my own notes at the time and then going back and reading the transcripts and watching the videos, see how these application processes unfold and what can we learn from them, for sure. But as Bob Reinhardt said, I think more questions were raised than were really answered. All right, well, so John Juza, maybe you can help us, or Aaron, I don't know if it's appropriate, in terms of what the judge is asking us to do. First, focusing on septic and the coastal site plan application, I think is the first task that we should take and discuss. And if anyone has any suggestions for language or for approval, denial, or what our determination should be, I'd be happy to hear.
Well, I think the first part of it is the coastal site plan. Would we approve it with the information that's in front of us upon considering the impact of the septic system? That's point one. Then point two is the special exception. Would we approve that given what's in front of us and our consideration of the septic system and its impact? Does that make sense?
I think it makes sense. Do you have any thoughts you'd like to share?
Well, I think based on the record and based on your analysis, which brings into really the background and all of the information from the hearings, right? It would lead us to believe that A, there is an adverse impact on the environment. Is it substantial enough for us to deny the application under the coastal site plan and under the special exception?
I get thoughts from other commissioners of whether we think we should approve or deny.
With the information that we have, and the fact that we had a number of questions that remain unanswered, I tend to lean towards a decline. That's my personal opinion. I can be converted otherwise, but I think we're bound by what we have. We're not allowed to take in any other data or information, and given by that, I think it's a little bit too inconclusive for us to approve. That's my personal opinion.
Yeah, it feels like an impossible situation. We weren't there,
Right,
we didn't live it,
right.
we're trying to look back. Seems like there's enough information there to raise questions, but, this is with, 2020 vision. So it's,
I too
Jeff,
lean
how
to
are you-
decline.
Well, just thinking about if we say adverse impact, what, I'm not sure if there's any specific fact we can say, other than when there's comments about the adverse impact, but that in basically anything we decide, we would have to back it up with something that's substantial to the record. I'm not sure if that engineer's opinion is enough.
Yeah, I think that's a question, but if that's what we have, that's the most substantial
That's what we're gonna get.
that we're gonna get out of the whole process and the transcripts and all the record, that's what we've got to go on. And again, we don't really judge one engineer versus another, we just have to read their words, basically. Bob Reinhardt?
Yeah, I think I'm siding with John with respect to this. I think the information in the record would compel us to look at this, that it does have it does look like we'll have a negative impact on the coastal resources, if not immediate, at least long term. There's enough information there that, like I said, I'd love to get more answers, but given what we have, there's a question with respect to one of the pits. I think it was pit 1. There was modeling which would indicate a seasonal high water, which then indicates that you're not going to get the septic filtering. Or not being a septic engineer, I'm going to use the wrong words, but you're not going to get adequate filtering. You take out the nitrogen, that goes downstream, feeds the Phragmites, and now you've got a stronger invasive species in the in the tidal area. We had that. There's just the density of the septic systems. While each one is designed for an individual house, they're very closely packed together. The indication was that would be problematic as well. And then some of the other, again, I didn't spend enough time, and I didn't think we'd get to that point in this meeting where we would go into the specific, this fact, this page, but in reading everything, the sense I have is that there's enough information to say this is a problem. And it may not be a problem today or next month or next year, but I sense this as being a problem at some point in the near future. And the coastal site plan is just incorrect, so that would have to be corrected and resubmitted, I would think.
Right. I'm wondering if we've digested a lot of information over the months, and I've presented it in under an hour. And if I don't know how everyone else is feeling, but if it would make sense for us to take more time to go through it again, think about what is really substantial and useful, or if we feel comfortable going ahead and decision. Just want to throw that out.
It's not on your agenda tonight to take any action,
Right.
so at least
So it would make sense then to just go through it again, think about it, absorb what we've discussed so far tonight, go back to the records even and double check and see that, we've captured what we think is pertinent information and substantive information to make a good decision, and I would extend that to the special exception.
Is there a date that we're supposed to respond back?
Yeah,
Is there a date yet?
no. I mean, I think it was last August.
I know.
Yeah.
But should we set a date?
But we've talked about having one more meeting.
Yeah.
Right.
To give it our final thoughts and make a decision. That makes sense?
Yeah, I think we need to move forward as soon as possible. It's in fairness to the applicant, to everyone. I mean, it's not like we're gonna get more information. We're not.
Yeah.
We
I think
can't.
I think it's a matter of just, making sure we feel comfortable with what we've gleaned from all the records. That we've gotten as much as we can, and we're ready to make a decision, and then have that conversation.
Do you have a record when you'd like to have this back on an agenda? What meeting?
February,
Which one?
the second one, actually, I'm gonna be out of town, CD, which I could possibly zoom into, but it's my daughter's graduation.
You don't want to do that.
So if we could put it on the agenda for the
15th, I think it is.
February
I think it's the 15th.
15th.
Yes.
I will not be available then.
Well,
Can we just pick a different day?
yeah, could we?
Yes,
have
let's do a
special
different
meeting?
day.
I'm gone that whole week as well.
You mean a special meeting?
Yeah, what
Could
about
we do an executive session?
February?
No, it's
We
be
will
public.
be an executive session, Janet, but it could be
Yeah.
a separate meeting.
It's not executive session, it's,
It's a regular
Regular
meeting,
meeting.
but you can schedule a special meeting. We can kind of poll for availability and then set a
would be
notice.
great.
let's call for availability.
Yeah, that'd be great.
Post it.
Maybe before our first meeting of the month? Bob and Carol, will you be? Carol,
Mhm.
you're away?
Yeah, I'm away.
Or you're away then?
Okay, well, I think the idea of polling everyone to get days that are available and then finding a special date so we can hold this and we just have this on the agenda, I think that'd be the best.
That would be great.
That'd be great.
Yeah,
Because I think it's important that everyone should be there. We should have a full complement.
yeah, I think so
Right.
too.
I think we should be expeditious about this, though. I think we
Yeah.
should try to
Yeah.
get it.
Maybe we can do it sooner than the February 2nd meeting. even.
That's true.
Aaron,
Yes.
I have a question. To expedite the pulling together of the information, how do we do that so everyone is not going through the records on their own and creating identical data sets? Or can we use a clearinghouse method? Can we rely on staff? I don't know I assume there's not a standard operating procedure for this.
Well, I would think that just as Carol brought to the meeting, then you would bring your specific sections
Okay.
citing to the meeting.
Okay.
Didn't we agree to give everything to Erin that we cited and she'd kind of put that together for us and that would go back to the judge?
No,
That's after we vote.
that there will be a.
Right, but-
Yes, that you can write your findings, but you'll have to provide those
Okay.
sections that your evidence and more detailed discussion here at the meeting
Okay.
first, before we can assist you with drafting.
I understand.
So that gives us a couple of weeks then before the February 2nd meeting to have a special.
Sure, I'll send an email tomorrow.
Great.
And see
Thank you.
That'd be great.
those availabilities.
Thank you. Thank you.
Okay, thanks.
Thank you.
Great. All right, I think that's it for this evening then. Move on to our second item on the agenda, which is the plan of conservation and development updates.
We may just a moment,
Yeah,
why
wait a
don't
second.
wait a quick,
This is the best part.
I'm not
people
sure-
can hear.
I'm not sure it's stated. in
So
South
who did it?
Carolina.
Oh, it's fine.
James, were you able to meet with Todd?
Yeah, possible. You might be able to zoom in, figure it out.
Maybe we can do.
Hi.
I can close the door if that helps with the noise a little bit. Oh, thank you. Oh, someone, I guess he's coming
That's
back.
the attorney.
Where'd everyone go? This is the best part of the meeting now.
Yeah, there's a lot of interest in the plan of conservation.
They're all going now.
Yeah, this is the hard part.
Now the fun part. The other-
Okay, so everybody can hear still?
Yes.
Okay. Okay, does everyone have the, if you want to go through the, do you need me, those online, do you have the digital copy that I sent of those policy actions, or do you need me to screen share them?
Maybe it would be great to screen.
I have the paper ones, everybody
We all
here
have
has a
paper.
paper copy,
Yeah.
and we emailed them, but I can do it if that's easier.
If you
I
could,
received it.
if
but
you could
screenshot
screen
would be good.
share only because, and that way we can look at it at the same time.
Sure.
Yeah.
That'd be great. Thanks.
Follow along.
Let me just get the right file. Oh, thank you, Carol. I forgot that door.
This is so well behaved. I mean, there's no fist fights out there, or it's not like the Jerry Springer show.
Okay,
All right, so the plan of conservation and development, we have an updated with a lot of comments, a lot of really good comments, a few edits that I think are fine from my perspective. This is based on the draft revision that I shared with everybody at the last meeting. Obviously with letters and numbers back in, which is great. And it does help, I agree.
oh, the door's.
Yeah.
I for one couldn't figure out how to identify myself as a guest.
I can say, well.
So I tried, and so
It started and I get into a problem.
I put my initials after it, just
Oh,
so
I didn't think of that.
so I could remember what it was.
Yeah, that worked.
I said, but otherwise, if anybody wants to sort of shout out their comments. I think the idea tonight is to just go over this and see if we're comfortable, and then also, I don't know if we want to try to answer some of these questions, or at least identify who can answer them, Erin, because I think some of this will go to John.
Well, yes, and what we
Right.
did the last time was based on the actions, he translated that into an Excel spreadsheet. So some of these we've already identified, so
Sure.
we can just kind of cross-reference that before the next meeting and see
Make
if
sure it's
anything
all there.
changes.
Yeah.
And I think one of the things that might be helpful is actually sharing that idea of who's responsible with those people, those
Right?
parties, so that the stakeholders can say, yeah, okay, but that's, just to get
Absolutely.
their feedback.
Yeah, but as far as I'm concerned, I think this looks really good
I was impressed.
as a draft, and, as the next
Yeah.
version of it, I think it's making good progress.
Absolutely.
Bob, I know you did a lot of work, and also you were trying to compare it with the strategic plan to see that we're in good alignment or complementing or whatever. And I think we want to make sure that you're not getting bogged down by that.
No, I'm not. I just looked at it real quick. I took I cut and paste all the focal areas, the goals and the objectives, or maybe it was the strategies, goals and objectives from the strategic plan that's
Right.
available online. I assume it's still a draft. And actually went through each one and I just grayed out anything that in no way would pertain, in my thinking, to what we're doing. And then kind of just visually looked at what we have down and what the Board of Selectmen have decided should be the focus areas for the town, and we are pretty much aligned completely. I didn't do a down to the nth degree, but close enough to say that what we came up with is supporting. I have to say I'm completely surprised that they're this well aligned. I didn't think it would happen, but it did. So I was wrong on that. But yeah, I think we're pretty much aligned with the strategic plan.
And the other thing I did is I went back to the state statutes because Bob or Mike Bugda, for example, you've been asking a lot. Can we reference this? Can we reference that? I found it very difficult because, well, a couple of things. The statutes just, they kind of have so much in one paragraph of what's to be covered in your plan of conservation and development. And I think we can say, yeah, we got those, but it's really hard to like say, okay, this is this one and footnote it, and then this is this one and footnote it. And then I also learned that they're drafting their next plan, which is great because I thought the last plan.
We all create everything.
I know, right? And then, but then I think what the direction they're heading in looks to be more of the sort of utopian type of values, systems and everything, like instead of pillars or whatever they called it in the last one, more broad. And but I don't think we have to worry. And also, I went and glanced again back at the regional POCD, and that's where we got our idea of natural and the built environment and not doing their human environment. But again, I think we're okay, but that would be great if John Skowski could
Just cross-reference.
just
Then
make
that will
sure.
be,
Yeah.
that's part of the process for sure to. And I think the other thing to remember is that this is not, it's mandated by the statutes that at a minimum of 10 years, update the plan, but it doesn't mean you can't make changes to this at any time.
Absolutely, and I think that
There's a
people don't
process.
realize it's a living document, and that was said also about the strategic plan, but our 2013 plan of conservation and development, I don't think it was ever touched or, changed. It was looked at and it was used to support.
Not sure there were any amendments made to that.
I didn't see any.
Sometimes, when another study is incorporated, for example, like the affordable housing plan,
Right,
or
a new
things, those
study.
can be amended and incorporated into the plans.
Yeah.
But,
With links.
oftentimes you'll have something like that, like in the future, if there's a bike and bicycle and pedestrian
as we
plan,
go through
then
the-
you can get into some more details and.
Yep.
And come back and revisit areas.
Yep. I just wanted to take a few minutes though to also add something about Madison's historic and cultural preservation, policy C. There's a really interesting conversation going on right now among preservation people in town, which would be the Madison Historical Society, the Historic District Commission, me, about the Daniel Hand house demolition, which is it's the birthplace of Daniel Hand, who is one of our most important people in Madison, and it is going to be demolished. And we did a site visit and documented what evidence there was. And then the follow-up to that was that Klima wrote a really lovely article about it in their newsletter, some history. And the Historical Society talked about writing an article or maybe getting something in the papers with a couple of photographs that we took of like the one existing fireplace that was probably from the 18th century. But it's raised other issues about collaborations among stewards of Madison's history. Like we have Klima in the archives, we have the Historical Society, we have town, and Aaron, you and I have talked about the town records and documents as being archives and their historical archives. I'm sorry, I'm carrying on a little bit too long, but it brought to mind that maybe, and it would be part, I think, it brought to mind what I did in Weston, Massachusetts, where I worked or lived and raised my kids. And I had an historic archives. I was the chair of the Historic Archives Committee. I was on the Historic District Commission as the liaison from the Historical Society. So deja vu. Here I am again, and I'm just thinking about how should we say something? I'm just pondering now. Should we say something about integrating these different historical organizations? And we've talked about how Guilford has what is it called, Aaron? Preservation Society or something?
Preservation Alliance.
Or, yeah, the
GPA
Preservation
is
Alliance.
there.
You know, I don't know if we wanted to add anything in the P O C D, but it's been on my mind because of this latest demolition of the Daniel Hand House, which is unfortunate, but really happening, so. Just, you know, if there's any way to
Facilitate cooperation.
yeah, facilitate cooperation, or I've even been thinking about, you know,
Maybe-
with the Academy School and
Well-
restructuring buildings and, you know, could we have, and I think the Historical Society has made more of a history center out of Lee's Academy. And then, you know, we'll have the empty family services building, I don't know, just throwing
What
it-
about in number 1, where you have develop a long-range preservation plan for Madison, and we add a letter C that sort of incorporates
That would be perfect.
this kind of collaboration?
Collaboration and alliance.
Right, because we talk about, you know, promoting by working with historic, or, you know, even in 2, but I feel like it might be better in number 1.
Yeah, and I think, you know, these different entities want to remain autonomous, but could definitely collaborate better, or, and again, Aaron, going back to some of the town records that need to be archived, you know, the historic deeds and documents that we have on file,
So-
which is typical of so many small towns where they're just in the basement of town hall, rotting, basically.
Build-
Aaron, who would own this?
Well,
What's it?
Yeah, good
it depends, I guess it depends if it's a town agency. You know, I think that's a question we have to kind of explore this a little bit. Do we want, you know, some of these groups are not town committees, they're, you know,
Right.
they're in town, but they're their own individual nonprofits, so.
Right.
I mean, it might be as broad that our historic district, or, you know, or we let someone like the Historical Society lead it. And collaborate with the town, you know, we provide some resources and with representatives from our historic district commissions.
Yeah, yeah, I mean, you know, as
But
far as
most
like
are-
archives
I feel
go,
like
we can
most are
bring in outside
nonprofits.
consultants. Yeah,
But I think this,
Well-
the plan could detail that a little bit more, how we, you know, if we get these, all the relevant parties together.
Right.
There's a lot of funding available for, historic preservation and even planning, which we
Yeah.
utilized,
Yeah.
through grants already. So that would be my suggestion, is
I
that
think-
we seek some funding and then we get those key players in a, you know, in a team to start looking into these options for this, you know, long-range plan, because it's not just historic structures or historic documents,
Madison
but it's
history is.
cultural landmarks, you know, it's stone walls, it's things, it's other,
Archaeological sites.
Yes.
Right.
Archaeology.
So
So there's,
broader than
There's-
just historic district.
I think there's two reasons behind this policy, which are kind of buried in there a little bit, maybe not so much. The first one is the idea that preserving history is just the right thing to do, to try to maintain that so we don't lose touch with where we came from, and all those other reasons you preserve history, but it's not, it may be atypical for a town to really dig into. But the second one is promotion of Madison's history to residents and visitors is an economic directive. And it goes along with I forget what the other one was. It might be the second one, which is the natural environment. There we go. Enhance the connections to nature in Madison. The idea of doing that is also to put together, and one of the goals in that is to create Madison as a hub for nature and beauty and attract people to come to us. So when you take the first three, the first one is focused on the economic, it's connecting people, and then there's another one with economic. But when you look at a couple of these, they all start leading towards the idea that we want to create Madison and leverage the value that we find here and preserve it at the same time, but also leverage it for bringing a greater economic viability to the town.
Yeah.
So if we look at that for policy C, I think it's fair to argue there should be a town function that takes, not, doesn't have to be, this is all it does, but a function which then has ownership of working with and pulling together the different groups within Madison to achieve the goals that we're going to set out. If we don't have that, then there's really almost no point doing this because it won't get done. You
Yeah.
need someone whose job it is to report back every 3 or 6 months saying, yeah, I'm doing this. Here's my budget. Here's how we're going to do it. These people said, no, we don't want to work with you, so we have to change our path. Or these said, yes, I got more people, whatever it might be, but maybe
Don't-
that's one of the paths.
Don't you think these organizations are already thinking about and working on
Yeah.
these things?
Yeah, I
we've
think they
had
are, but
Conversations already, I've
Yeah.
met with historical societies, about this idea of collaborating.
Right.
And
so
I
maybe
think-
it falls to your, I'm sorry, go ahead.
Yeah, no, I kind of tend to agree that it would likely be housed in the land use department.
That's
What else is new?
Tag, you're it.
But it makes me think of the certified local government and,
Yep.
and
Yep.
that was a town initiated, the historic district commissions,
Yeah,
established,
yeah.
these are all town initiated, opportunities really for,
I mean,
Yeah,
preservation.
I think it could go, it could go through the Historic District Commission too as the town entity and, have liaisons say, I don't know if that makes sense, Aaron, but first, I think we also have to make sure the Historic District Commission is more functional.
Yeah, it could just come from my department, seeking a grant to collaborate with these folks and bring them in. It doesn't even have to be necessarily that a formal organization. They're just stakeholders who are involved in the process.
And I'd be happy to help write the grant. I wrote the CLG application with Dave.
So,
with David.
Does that make sense? I just kind of put a letter C, collaborate with various preservation,
I think that's great.
entities. I don't know, well, I'll kind of, once we get the rest of our feedback, what I was gonna do was just kind of send this along, have a conversation with John so that he can see the direction we're going and he can help finesse some of the wording or perhaps, give us feedback for the next meeting.
One thing that I liked, I told Aaron that I really liked about this is I feel like it's easy for the first time. It's easy to read. It's easy to understand.
Yeah.
It's giving different stakeholders their directive, which they already have. They already know. It's going to be easy for someone to pick up and read and understand what we're trying to say. And I think for the first time that's happened. So whether it's Bob or a combination of people, Carol, Aaron, who have worked on this, thank you very much. I have not had time to work on it and said that I wouldn't, but just as a member of the public reading this, I think it's, we're getting to where it's really what we want it to be.
Right, and I think really it's just, this reminds me, this format is very similar to our affordable housing plan. How we went through policy and our action items and then created, a table after that for the groups, with
For
some
implementation.
priority timelines of when we would estimate these things being completed or,
Can I ask
started.
something on history?
Can we, we can listen to the public.
Just somehow encourage adaptive reuse to preserve older buildings fell off. That was in there in the July draft, I think it was.
Oh,
For the record, could you
The built-
identify yourself?
Built environment F2, and it seems like that would add in nicely as number 4 here.
How about number 3?
I don't see number 3.
By the way, could
To
you identify
promote
yourself?
preservation and discourage
sorry.
demolition
through
through adaptive
adaptive
reuse and other options?
Oh, okay, I'm sorry, I didn't see that. I'm
That's
working
okay.
off the
January 17. No, I'm working off the December 7th.
Oh, that's a really hard one, because that
Draft.
was like before we
And then
accepted
Jim Norton,
everything.
387 Boston Post Road.
Nice.
Okay, so that's back in
It's
there. I
still-
just wanted to
it's
make
there.
sure. Okay.
Yeah, so the goal really went from the December meeting was to take all of the actions that came forward from that were originally separated, the built and the natural. We used that meeting to kind of propose the merged policies,
Consolidation.
right? That, because we found that they crossed over quite often over the natural and built.
Which was the
And then-
whole idea, really.
Right.
Yeah.
We did a table of all those existing actions to see that they
I'll get
were
up to speed on it as
picked.
soon as I can.
Do we have
see that
another
draft.
copy of this one?
I don't need to see it now. That's all right.
We can steal one of those.
Yeah.
There, yeah, and Bob's.
Can I make another comment or?
Yeah. I think so.
Okay. I noticed that, farms are missing entirely from, the P O C D draft unless it's included. And I mention that because there was that one line about using farmland across town, and I don't think that was the point of, Heather Crawford. Thank you. We kind of got lost in the discussion of,
Yeah,
are we
yeah.
cutting forests up? But it was about farm preservation. And I noticed, even in the Connecticut law, that says POCDs have to add something about protection and preservation of agriculture. So it seems like farm protection should be in there somewhere. And if you have had a chance to read the approved strategic plan, it specifically mentions preservation of not only open space and historic features, but farms and scenic roads. So, as Rob was saying, they're supposed to dovetail. And it seems to me if the Connecticut recommendation is to have protection and preservation of agriculture, and we had a knot in there originally, and then it got out because it was confusing. And the Board of Selectmen have in the strategic plan protection of farmland, scenic roads, historic buildings and open space, that somewhere it's missing in here, and it should be in
So-
there.
Yeah, a couple of things. I think specifically it is missing. But although at some point in the past, we talked about having these kind of sidebar or boxes with definitions, because we talked among ourselves about what's open space, what's natural resource,
Mhm.
is the golf course a natural resource when they use so many chemicals and it's all man-made?
Yeah.
Or, but it is kind of an open recreational space. So I think when we write that and get that clarified,
I think it should be more than just a box. I think it
yeah,
really should be a major
Yeah. I
category,
got it down.
especially since Board of Selectmen went out of the way to mention it. And scenic vistas or landscapes also, I'm not sure where that would fit in, but I go back to the visioning sessions that I went to, and I'm sure you were all there too, but resoundingly, it was protect open space, forests, scenic roads, historic buildings, town green,
Trees.
cultural heritage, et cetera, et cetera.
Yeah.
So,
I don't know if Connecticut has scenic viewscapes. I think Massachusetts does. But we do have scenic roads in here, but we could expand it possibly as more of a viewscape. I don't know, gotta think about it. And where
What
that
is a viewscape?
viewscape is just like your wider view, not
well,
just.
that's really important because the scenic roads are only a small section of
Exactly.
town's
It's
overall
very-
roads.
and it's
the
very
intent-
narrow.
The intent from the citizens was, we like the way it looks, whether it's stone walls or farms or forests or
Yeah.
trees or whatever it may be.
The other thing we don't have in Madison is any kind of height restrictions for building on the water, so that, people can build these huge monstrosities, these huge and elegant
do.
dwellings.
We do have,
We have height restrictions, but not in terms of viewscapes of, protecting a view,
a view, yes,
right? So,
that's with respect to coastal.
Yeah.
And just one last
applications.
plug on the farms, we do have 21 farms in town that are getting, at least the last data, getting the property tax rate. And I know
The
one
PA 490.
commissioner said, or do we want to be a farm town? Well, obviously we're not a farm town, but Guilford and Durham, our neighbors, are farm towns, and we do have 21 farms. And it even moves into sustainability and climate change.
Yeah.
If there's no water in the west, if it's so dry in the west, shouldn't we be trying to at least preserve the farms we have here now? And interestingly, Peggy Lyons' comment at the strategic plan was her vision for economic growth include agritourism.
Yeah.
And you can't have agritourism
That
without farms.
Okay, thanks.
That's it.
Good comments.
Would we consider the farms a cultural component of the town? Are they old farms? They've been here a long time. Trying to think where we put that in.
New people growing herbs and garlic, whatever is, and maple syrup. So they're old and they're new. It might be part of open space. I don't know.
Yeah, I think of it as the open space.
I think it's more open space, but that's why I was saying we need to clearly define that too.
And on,
Maybe we don't. Okay.
on the open space, when we cut down from 8 or so to 7 policies, number F was removed. And I just want to rethink that. Develop stronger strategic approach to property acquisition. And again, that was a big theme at all the visioning sessions. That was important to the Madison Land Conservation Trust, of course. And I know the components below that, that was formerly F, I believe, are in there, like an open space plan and budgeting for an acquisition fund, right of first refusal, et cetera. But when I look at the remaining policies, I don't really see, it's a plan of conservation and development. So just kind of a perception thing. I mean, if there was a good reason to take that off.
What was I didn't catch could you say again what the policy was called?
Yeah, it used to be F, before they
Right.
were renumbered. It was called Develop Stronger Strategic Approach to Property Acquisition. And that was Ben Diebold's big thing from the Madison Land Conservation Trust. So I know.
Right, I think so. I remember now. And I think just so maybe I can try to explain it. I think the idea was that the act of acquiring the property is not a standalone item. And we wanted to look at it as part and parcel of the open space, the connecting nature and Madison to the people, and take that route. So it's part of a larger approach to things, and that the acquisition of the open space is the strategic approach to doing just that, but it's not just for the sake of doing it.
Yeah, it makes sense. As long as it's.
It would just
not
ought to be more powerful,
subservient
actually,
and
to-
being kind of lost.
I mean, we have it in,
It's in 3A.
yeah, well, and I see it in B.
But it's not.
It's in B goal too.
B3A.
Yeah, those points are in there, but it's not a headline as it used to be.
So we worked out, we changed a little bit how we think about our goals and our policies and our actions.
You don't have, as long as you,
So-
as long as you.
Yeah, I get
thought- I didn't hear any discussion on why the categories were changed, other than to simplify, and it's simplified and it's well organized. I just want, if there's a
That's a
reason.
good point.
But if it just was forgotten, then
It's not forgotten, it's just
Okay.
maybe changed its, like, is it a strategy or an action?
just as long as it's not de-emphasized.
Yeah.
No, it's not. Right, I understand your point. It's a good one.
I've got another.
So it's a support.
Another perception change I want to talk about in policy A. I think we should combine 2 and 3. I think if we have put the bicycle and pedestrians separate, it really should be part of that whole multimodal transportation plan.
Then you
Yeah,
start
I
getting-
agree.
Then you start getting into more than 4 items under a heading.
But I think we can do that.
But yeah, I think that bicycle pedestrian would be a very important part.
Oh, you want to promote it, yeah.
Right.
Two references pedestrian anyway, as it is.
Yeah.
So
Yeah, I think,
So combining them seems to
Combine
make sense.
those three into
Agreed.
one. And even 4B, the seek to connect usable property to the shoreline greenway, maybe that should be part of the
Multimodal.
multimodal unless.
Yeah.
yeah, I,
Two more transportation oriented and make the third one specific to bicycle pedestrian.
See, I would,
I kind of rolled them all together. I just said, and I didn't include it in the changes that were submitted, just some additional work I did. Establishing a townwide transportation plan to better connect the community, and then all of those components go underneath that. And it's how we connect the community together, and it would include the bicycle pedestrian path,
sidewalks.
the shoreline east station, sidewalk plan, connecting municipal properties, but it's all part of a holistic approach to making it easier to get around Madison.
And we want to encourage people to walk
Yeah.
and bike,
Yeah, that's,
Which
Well,
brings
how
up-
do
get out of their cars.
which
right, get out of the car.
brings up another question. I know
Healthy.
I just lost it. We talked about looking at alternate parking areas. Is that the right way to present that? Should we look at,
What letter are you on?
I was just looking at it and I just lost it.
Well, it's.
No, I know, there was, there were
Provided
two,
use of parking areas
For that, yeah, it
under
says-
policy A number 2C.
Yes,
Yeah.
exactly, yeah. Is that the right way to present that? I mean, do we, almost like, well, do we need more parking? Do we need more parking, or do we need more, do we need better access through this multimodal plan to downtown, through bicycles, through walking?
I feel like that, some of that stemmed from the conversation of the town's former lease of the Amtrak parking lot over on Bradley Road, and some of those available areas of pursuing, or renewing a lease and making improvements, and also connecting back, I think, to the Bradley Road vision study of some other opportunities for parking downtown. To maybe, I don't know, it kind of dovetails on some of the newer zoning trends of reducing parking requirements and having more shared,
Yeah.
Yes.
and less impervious development on individual lots. So we could kind of agree a little bit.
I tend to agree. I've never liked the idea of just saying we need more parking downtown without someone doing some kind of study or an assessment to say how much more and where should it be. I mean, yeah, downtown gets crowded if you try to park on Main Street, so park and Stop and Shop, I've never had, I mean, personally, I go there all the time, I haven't had trouble. So it's too simple and too broad.
Yeah.
And it's not connected to some kind of benefit to doing it. It just sits there.
Excuse me, you guys, we've hired John Guskowski and his company to do this for us. I thought, and maybe I'm wrong and I misunderstood, but I thought that's part of what he's doing, that we're doing the basics, and then he's going to come in with his group and we're going to get these sidebars and the boxes that Carol was talking about. Am I wrong? I mean, this isn't the whole document we're looking at right now.
To hand it over to.
Yeah.
Right. But they're
No, but I
going
say
to be-
Responsible person or entity.
A
for the
professional.
parking. Is what you mentioned.
So our consultant has been hired to draft, to assist the commission in drafting the plan. So yes, they're writing the plan. So you don't have to get bogged down into necessarily all the words, but I think it's helpful to just some of the general, John, can you add something about the importance or why we're talking about parking downtown?
Sure.
That aspect, but yes, you're correct, Janet.
Okay. I thought we'd
Well,
done that. That's why I'm confused, because I'm thinking, we're getting in the weeds about the basics, and I think it looks, for the first time, it's not confusing, it's simplified. And then from there, we go into the more detailed aspects, which aren't here, which you're not looking at on the screen right now. So, and the gentleman who's in the audience is not looking at that. So I'm just saying, I think we're spinning our wheels over something we don't need to right now.
Well, I'd offer a different perspective on that. John and his company are consultants, and I don't think they should have the ability to define what's in the POCD. That's our job. We have to own it. Their job is to make sure we don't miss anything that the state requires, that we don't miss anything that the region requires, that it makes sense from someone who's written a lot of these, that we haven't, bungled it all up together and it makes no sense. But we have to take complete and total ownership of, to me, the rest of the document is less relevant. This is the heart of the document. This is what everyone's going to look at and say, I want to build an XYZ. Does the POCD support it? And then we have to say, yes, it does, because we thought it was the right thing to do. John doesn't get to say that. He gets to tell us how to say it, but not what to say. That's how I look at it. And so specific to the question of additional parking, I don't have the benefit of having sat through the discovery parts of this. But when I look at that, it's, yeah, we want more pedestrian access downtown, but what does additional parking mean? Before we put it in here, because that means someone's going to try to build a parking lot somewhere and saying the POCD said I can do it.
Yeah.
We're telling someone to go build more parking.
Or
And that's
parking
not
garage.
necessarily,
That was in the
Right.
vision of the study.
so that's,
A multi-story car park on Bradley Road.
So it really is a
that would be a
must.
bad idea.
Do we need more
I
parking?
think you're both right,
downstairs
Bob and Janet, and I
Or not?
didn't take it as the fact that, or Janet's comments really, that you didn't have to own these, because I agree that you do, clearly. You have to be able to back these up and understand what happened in, what was in the last POCD and interpret the feedback you've gotten from, and try to address that. But I think some of the wording and that kind of, finesse, we can give a marked up document to John and he.
Yeah, agree completely on that. Yes, I agree on that completely. He's going to wordsmith it so that it makes sense and it's beautiful.
Yeah.
Okay.
Let me ask a dumb question. Is there evidence that there's a shortage of parking downtown? My personal experience is that I've never had a problem finding a spot. It's not a rhetorical question. I don't know what the answer is.
Complaints about the main, post road parking gets filled up, but I agree.
Yeah, but
I
there's
have
plenty
I guess it
close
depends
next
on where.
by.
Well, I also walk.
Away, it's
I
not a
live close
problem.
enough to
So,
walk into town.
so I would not think we want to encourage more parking.
Train station's empty all the time.
Yeah, no, it's, yeah.
And so's the Amtrak lot.
And Stop and Shop, it's not empty, but there's,
Yeah.
never seen it, maybe July 4th.
Yes, Granite Park
Except
is
for
always
July.
open.
The other 364 days.
Can we agree that we're in a good place Bob, do you want to tweak this just a little bit more?
Do you want me
Can
to?
I ask just one?
Oh, yeah.
One more
Sorry.
question? In the CP harbor, assist in the creation of a harbor, I know we talked about that, I just don't remember. What are we actually asking?
Yeah,
Good question,
and
Josh.
Aaron, I think, added waterfront use plan to it, which is probably a better way to say it, because I was promoting harbor use because I've seen a lot of chaos out on the water, and I thought, and other towns have it, and it's something that you can do, it's part of coastal management, really. And so I threw it out as an idea, but I think it's, by qualifying it as waterfront use plan, is there something else that you don't understand, or how we should, maybe the words?
Assist in the creation of a harbor, to me, seems like a.
So that relates to a harbor management plan. So there's certain, if you have public docks, things of that, you need to be able, you need to manage those areas through a harbor management plan and a commission.
And
So
I
I think that kind of initiated
Yeah, and there's
some
even
of the
a balance
conversation.
between the public and private use and waterfront access. You know, so we've got East Wharf, West Wharf, and you've got the beach club, then you've got all people putting up private docks in front of their houses. You've got jet skis on floats out there, you know, and we've got yachts for moorings crashing up on the rocks. You know, that was what I was thinking about when I thought we needed some
Yeah, some of these may
a little more control out there.
use
For
and
the guy
safety
who went
policies.
fishing
I'm
on
not sure
his
what that means.
paddleboard and ended up getting a Nantucket sleigh ride from a shark.
Oh.
That's when I said we need. Anyway, we can take it out.
Not a bad time.
Or we can try to define it there. But maybe
Yeah.
John can do that, because
Yeah.
there's something that is specifically a harbor management plan.
Okay, so should that say assist in the creation of a harbor management plan?
Yeah.
It might, yeah, these are two different things. So I put a note here that this needs to be defined further.
Okay.
Yeah.
Good, that's that.
If it's specific, a recommendation for a harbor management plan versus, you know, is this municipal waterfront use plan versus private? I mean,
Dredging a big harbor or something, that's good.
I don't think it's a really touchy, very controlled, but yeah.
Can I make one last comment on
It's not too long.
Right, on E, there were some questions on E, focus on property acquisition to limit vulnerable development along shoreline. And I know there were concerns about that, and I see in the margin, several commissioners were not comfortable. I just want to mention, there are FEMA funds. This is not eminent domain like people were fearing a couple months ago. These are willing sellers of flooded properties. We worked on a project in the town of Trumbull, and homes were constantly flooded along Quonic. And there's FEMA money, town has to agree to accept FEMA money. They bought out flood-prone homes.
yeah, there's just an article.
And it's voluntary, it's not, should not be construed as we're taking your land, as people fear, of course, that wouldn't be. These are people who have been flooded so many times and they never get enough insurance back, and they say, please.
Yeah.
And it's better for restoring the salt marsh. So, to clarify, it's not taking, it's not eminent domain. There's FEMA money if the town agrees to accept it. The town of Milford has agreed to not accept it because they like when people on the coast rebuild constantly to keep their tax base up. Can you believe it? They
There's-
declined it.
Their choice.
Right, it's a tool that's been used. I know that question was raised, and it might have been John or Mike who raised that. And it's usually where you have repeat claims for flood, and they're low-lying areas, and exactly, you can take that for flood protection, for wetland, tidal wetland expansion, things of that nature.
What are the conditions for taking FEMA?
Yes, of course, there's always a catch, Jeff.
I don't think
But
so.
it is, and it's usually initiated with the floodplain administrator.
Yeah.
They've done that, in Guilford as well, and Branford as well. I only know that from my experience working with the town engineer in Guilford, who served in both towns previously. But it is a common, not necessarily that common, but it is a standard of
It's the way to do it.
practice throughout the state. So there is some benefit, especially projecting sea level rise, and that will likely come up as, you know, the coastal resiliency plan, things like that are updated.
Are we talking specifically about 4B?
It is no,
I think it's
it's,
E.
Yeah, 4B. It's
It's-
E,
4B.
policy E, 4B, right. So in that scenario with FEMA, does that cost the residents of the town anything?
I
No.
have to investigate it, I don't know.
I'd be more specific. You can use any of my tax dollars. I can use any of my tax dollars to buy someone's house who's been
from a
flooded.
flood perspective, you know, repeat claims can have an impact.
Not my pro,
So
but
in that
I
sense,
think
be a benefit.
you know,
but it's not. I personally have,
It's not taxpayers' dollars subsidizing purchasing private property for them.
Or building.
it is
bigger
not.
houses.
right,
No,
no.
Well, that's not town taxpayer dollars.
Right.
Still
Yeah, I
taxpayer.
mean, FEMA's regs in this are always changing. It's been a concern for years that why do the taxpayers have to pay every 3 years to rebuild this McMansion?
well, and some of those expenses are now more directed onto the property owners who are.
So
paying
exactly,
upfront.
it's
been
FEMA's well
reduced
aware that this is,
From the
we don't want to
taxpayer.
create this type of.
I can get you more information on the type of program, so at least you understand it a little better to kind of weigh whether you like it or, you know, it's something that you could support or not.
Be great.
One other thing.
Yes, of course.
There, policy F, 1B, is the district including North Madison Circle. There should be
Right.
some
Right.
comments around that.
Yep.
Do we need to talk about that?
I'm happy to take
Commission.
that out. Yeah, there are a lot of comments about it, and Lisa, I think you made really good points.
Oh,
John
thanks.
made really
I'm
good
not
points
sure-
on that.
I'm not sure if I was getting unnecessarily excited or alarmed. I guess I'm kind of confused about what the possibilities are. And just like with this FEMA discussion, maybe there just needs to be some more information to clarify it.
Mhm.
Well, I think it's a consideration that, and some of that was raised from folks in North Madison saying, where can we go get a coffee? Or, you know, those kinds of having resources available to our residents in the north. It wasn't necessarily spelling out certain areas, and I think the language of one, you know, appropriate scale economic development and the consideration, I think the conversation will likely continue. It was brought up in the 2013 POCD, and we have heard feedback on that. So that's why it's here.
I think it was in some of the strategic planning sessions too.
Yeah, I mean, that's why it made its way. It wasn't,
Is it
Sounds like
still-
economic development.
I think we can make we don't have to be so specific about the language. for
Yeah, I
sure.
think actually in John's comments he basically wrote what I grabbed, which was revitalize and improve existing commercial zones with new businesses. As I thought it was a good starting point. It's not saying put more stuff on 79
Right.
or any place. It's saying we have commercial zones. How do we make them better? What's
Yeah.
missing? What's in the way? So you can have the coffee shop and what's appropriate.
Another porta
Makes sense.
potty?
well, yeah, I guess you have to look at the other side of being specific, saying the existing commercial zones aren't changing. So I think that you have to understand where, not saying that there, but moving in the future, if there are other opportunities for redevelopment or specific, I don't know, I'm just playing both sides. I don't know that you want to be that specific.
But there's also, but we capture that in maybe I wrote it separate, but I think it said consider overlaying planned development districts on commercial light industry and transition zones in addition to all residential zones on a case-by-case basis. So if we have the commercial districts that have been defined for, I'm assuming, decades, and we think there's an opportunity or a benefit to adding a new commercial zone, that defining how we want it to look, then we can, Aaron, I think even you wrote this one, it's like, then we can say, okay, here is a good place for more retail businesses and get the input from the residents and whoever. But then that allows us then to say, we've got good stuff now, let's make it better. And if we need more, we have a pathway to do that. That makes sense? Or is that too broad?
Makes sense to me.
So if you have that 3B, you actually need one.
Well, this is, I mean,
The Board of
There's
Selectmen,
one-
when they talked about the strategic plan and economic development, they specifically said North Madison. And they said the two ends of Boston Post Road. That's what they were
I remember.
indicating.
Yeah.
Those are existing commercial.
Yep.
there's the rural shopping district is the commercial zone, which is the Roberts Plaza. there's also opportunities, I think, looking at how the commission established a village district within Madison Center. There's opportunities for establishing village districts in other areas of town that could provide that sensitivity. So I just thinking of how, and we don't know what, but, it's not necessarily attracting
So,
new businesses, but to understand, well, it could, but I think just your language of consider supporting establishments of small businesses outside of the downtown village district and left it at that without the area in parentheses is,
But it seems like 1 and 3 are basically saying the same thing.
so which part, 3B?
Well, talking about zoning is significant. Changing zoning regulations, that's different.
Yeah, we're not trying to do.
yes, you are there. It does say the same thing. And that actually you could roll up underneath a broader definition of one.
I'm not understanding how they're the same. I guess that's so the 3A is specific language to try to address the area of site-specific special exceptions that are in the zoning regulations, to convert those to some other type of a planned development district approach, rather than allowing these text amendments to have a use. It's essentially spot zoning. So that's what A is. And then B is this concept of a PDD is only in specific areas in residential zones and not in commercial zones. And that was one of the items raised, to consider that when doing the comprehensive update of the zoning code, to look at what that looks like. That's different than looking at they're two separate things in how I read them.
I see 3 as
So is
zoning regulations.
Correct.
Yeah.
So is 3 really just cleaning up the zoning regulations now from all those text amendments?
Somewhat, yeah.
That's A.
Okay.
And to get rid of spot zoning.
And then to look at other tools that are available, rather than blanket changes to zoning districts, which applies to all properties. If, the statutes allowed for, various floating zones and.
Right.
these
But
things like
I think-
that. That's what that means.
But I think so. I understand A. It's good to talk about because I misinterpreted what that was. But for B, it's really I see that as part of the work of identifying opportunities for expanding appropriate scale economic development and services. It's a tool we have to do that. Right?
It is expanding the PDD concept to other areas of town. It says,
Right.
in addition to all residential zones, also the commercial zones.
Light industry and.
So, it could.
Okay, it doesn't matter.
It could yes, it could apply, and you could use it in North Madison if that went through. But does that, I don't know,
and just a different topic. It was brought up that the strategic plan specifies North Madison and the east and west ends of Boston Post Road. Where is that? Because I have all the goals and objectives and under the thriving business and economy. I can't find that specific. I don't know if that's an older version.
Those are the
And
comments from Peggy Lyons and Janet Gordon, when people were
okay, well,
concerned that the language said rewrite and change zoning to blah, blah, blah. And people were concerned that they were missing a step. So they changed the wording to say, study and evaluate zoning changes, so that the public had full participation. So it's, Rob, it's not written down. Those were the comments that the Board of Selectmen made when discussing this.
So it's.
So maybe
it's-
that's why North Madison got picked up in this.
So is
No.
that,
Came
is
from,
the intent then for those comments to update the strategic plan that's online? Is that what the timing is? I'm just a step behind.
is adopted, Bob.
That was a
Well, then that's not-
clarification of the strategic plan, and you could watch the YouTube and.
Okay,
those
all right,
are
so
some-
it's just comments. Okay. All right, it's comments. Got it.
One last thing on this plan, PDD, kind of the reason I'm here, because I like a kind of a caveat in there with public participation. Because we had a brouhaha in December, January, and February about the PDDs. And at some point in the time, Chair Snow and Commissioner Peckinpah said, definitely have to have public participation when we're considering or changing PDDs. And everyone agreed on that, and everybody would agree with that.
That's standard procedure.
No, it's never been that way. We never had public input.
There's a difference between the Planning and Zoning Commission initiating a comprehensive update and review of their zoning code and an application being received from a member of a resident proposing a
I
regulation.
think the discussion was
So-
about the PDD concept in general. Some people said we should not even have a PDD. But I thought that reasonable consensus was, if you're gonna change or have a floating zone in a residential area, there's gotta be public participation. But there isn't.
Well,
If you go back to the minutes of 2020,
I think this is a conversation maybe for another time.
right, so I
but-
just want a caveat in there, like a footnote or asterisk.
I mean, we have public hearings and we had, for PDDs, we have a series of public hearings. We got public feedback. We changed it. So,
Well, if you look at when the opportunity areas were first discussed by the P and Z Commission in 2020 and adopted, they listed specific things for public participation. They said our guidelines are to have letters to all property owners in that district. Who could argue with that? Never done. A dialogue with people in
Can I-
that
can I
district.
just- I'm
Yes,
sorry, I think we're going down,
I just want to raise the point.
we've heard you, yeah, thanks. And we'll think about it. And there will be other opportunities to have more of a conversation about what's a better way to do it than our system that's in place, but I kind of want to move on to
Excellent,
other
gotcha.
things in the
Just want to
agenda.
raise the point.
Thank you. Anything else?
On this plan, policy G, which is diversify Madison's housing supply, I think it's fine. But why are we adding this where possible and practical? We don't do that anywhere else.
I put that in
Oh.
because I felt that it was just too open-ended.
Well, I guess we don't use it anywhere else and it's implement the plan, so. I don't want to, it seems to weaken the affordable housing.
I have no objection. But I thought it was too open-ended and allowed far more than what was stated. That's all. I didn't think there was any harm.
Yeah, if you don't mind, I would remove it because I think it's fine. We don't use it.
Okay.
That's fine, I understand. And it doesn't go beyond the housing. That's not my interpretation.
Yes.
It's not the only.
I got your point.
All right, we good?
I would just, I mean, I took notes.
There's gonna be more opportunity to talk about.
Right, if you had something jotted down that you wanted to email that I can pass along with these notes to John, feel free. If you're not ready for tomorrow, I'll wait till Monday and get that information to him. I know, Bob, you had things drafted. I don't know if that's useful to share or not.
I also want to say thanks again to Bob Reinhardt for all the work that went into that, so.
No, it's not just me. There was
Now we got a long
on it.
list.
I had a whole,
Everyone else
we had a crew.
We've got good comments, and I think we're in a good place.
We had a couple of Johns and a Bob.
Johns and Bob's.
True.
And a CS. Good, all right. I think we can move on then to the next item on our agenda, which are a couple of receipts. And Aaron, it looks like we need to make motions to table these.
Thank you, good night.
Good night.
Good night.
For your best.
Don't
All right, thank you.
Your vest.
You want your vest?
You'll get outside and realize.
You'll figure it out.
You know, they say when you leave something behind, it's because you want to come back.
Ah.
That's not true.
Your best, your best.
Thank you.
Yes, the 2 receipts should be tabled to the 15th.
So
Of
we need to make a
February,
motion-
sorry.
Can I have a motion to table these 2 receipts? We can do them together.
I'll sit.
And any discussion? All in favor? February 15th?
Aye.
That's especially good, Aaron, if we're doing the remand on a separate date, so we don't have to worry about loading it up too much.
Sure, and the only delay is because they're coastal site plans, so they've been referred to the state and they asked for 35 days
Another
to
extension.
provide comments.
Okay, great.
Governor's Way was already received, but we tabled it to this evening because I wasn't quite sure the applicant's timing for receiving their COP from the state. And they asked that we push it off to the February 15th meeting just to give them more time to receive that permit from the state first.
So another motion to table.
Provide a motion now.
Second, any discussion? All in favor? Okay, great. All right, Aaron, administrative approvals for Island Avenue and Scotland Avenue?
Right, so in section 29, your site plan regulations, most of the site plan modifications that you see as a commission are considered major alterations, but there is a provision for a minor alteration, and it allows the applicant to go to ACCA if it requires a building permit, and if it's within certain parameters, square footage of disturbance, things like that. It does give the zoning administrator the authority to issue that permit and just report back to you and let you know that they've issued the permit. It's basically an agent approval.
Okay, because I mean, the windows have already been done.
Well, yes, and there was some confusion in that the beach club obtained permits through the building department, and due to a glitch in the permitting, how it was applied, zoning was not included on the review of that, and so we caught it after the fact when they came seeking a permit for AC condensers.
Did that have to go to ACCA?
It did.
Okay.
So both of these went to ACCA at their meeting last week, and had favorable recommendations. So Maria, as the CEO, issued the administrative approvals for both of them.
So we don't need to vote.
Oh, you're just telling
No, it's really just informative. The regulations require that we report back to you. What's that?
We wanted to make. Just kidding. And same with, I mean, with the restaurant.
But what are they doing?
Barbecue.
They're working.
They're putting a bigger.
He replaced his
sort of
awning, yeah.
awning tented area with it's a more rigid structure, it looks like.
Well, it's the same structure. There used to be a big tree in the patio, and so the outdoor dining was designed around that, and the tree died. And so,
Tree died.
so they wanted to tee off that corner and square it off, so that it was a rectangle and not
It
that
looks good.
irregular shape.
So it's not greater square footage, it's just.
Well, it is around
A little
the
bit, 'cause
former
tree's gone.
tree trunk.
Oh, okay.
Some of the actually.
Is that a zoning issue?
Yeah, the right of way on Scotland Avenue is really wide, and so there's a portion of this area that's within the town right of way. So they have to obtain permits through Public Works as well for encroachment, and Guillaume is in the process of doing that, so.
Okay. All right, and speaking of regulation changes, the childcare.
So it was brought to our attention from the Board of Selectmen, or the first selectman receiving a letter from OPM, which is the Office of Policy and Management, that there had been an amendment through Public Act 23-142, that it seems that all the planners and all the zoning, I'm a member of both, nobody caught it until these CEOs were getting letters of verifying whether our municipality is compliant or non-compliant with this change to the regulations. There's always been language in the statutes that requires your zoning regulations to treat a family daycare home as defined in a specific section of your statutes no different than a single family house. But they've broadened that now to include a group care home.
Group child care.
And that's, so it's a group child care, so it's in the home, it's defined by the statute, but it has to be treated no differently than a single family. And our regulations lack that specific language that references a group home. It's not a daycare facility, like a commercial facility.
Right.
That still can go through the special exception process. But so we provided a letter of non-compliance this year to OPM and indicated that we'll address this winter to specifically February to bring our regulations into compliance so that moving forward, Peggy or the first select person can report to OPM that our regulations are consistent with the statute change. So I was gonna just draft you some draft language change. It's specifically in our residential sections, which is section 3, and our rural residential section. And bring that to you, if it's okay, at your next meeting, so that then you can schedule a public hearing and we can get the appropriate referrals going to SCROG and neighboring towns. It seems, and Carol, you're on the Regional Planning Commission. This seems to be the trend in all municipalities.
Happening in other municipalities.
Scrambling to
Yeah.
just update the regs to be consistent.
Yeah.
So
Okay.
that's, I just wanted to
Okay, thanks.
keep you in the loop.
Heads up. All right, approval of minutes, John Juza.
Sure. January 4th, executive session. Members present, Snow, Peckinpah, Reinhardt, O'Connor, Bugda, Rubin, and Downs. Is there a motion for approval? Okay, second? Great.
I'll second.
Any edits or corrections? I got
Good.
one. I was there. I need to be listed as a present too.
Oh, good catch.
That's
Okay.
easy for me. Okay, vote to approve.
As
All in
amended.
favor? Great. January 4th, regular meeting. Members present, Snow, Duza, Rubin, Reinhardt, Bugda, Peckinpah, O'Connor, Downs, and Morgan. Motion for approval? Great. Second? Thank you. Any edits or corrections? I
Hardly
didn't,
The
I didn't
joy
see
of
any.
the executive session.
Yeah.
I did those.
fonts were up.
People killed the night off for that one.
Okay, all in favor? Wonderful. Thank you.
Thank you.
Okay, great. Under remarks, let's see, I just wanted to mention that I'm going to the Board of Selectmen meeting on Monday to give an update on the POCD. And Bob, you're getting credit for the basis of the PowerPoint that we're putting together. Bob Reinhardt, thank you so much for that. Anyone's welcome to come. It's from 7. I don't know. I haven't seen the agenda yet, so I don't know.
It's gonna post tomorrow. I think it's
Yeah.
mostly discussions,
Yeah,
updates from
Yeah.
folks. There's not a lot of action items, so I'm not sure where you
I think
fall.
it's in here, right?
It's hybrid.
It's hybrid.
Yep,
Yeah.
so it'll be in person
Yeah.
in this room or online.
And then I just wanted to mention again that I'll be out on February 1st. So Bob, if you could run the show, that would be great.
I knew there was some catch to this whole thing. All right, I knew it.
A month later, devious. Anyway,
Training wheels are off.
Damn.
so thank you for that. Okay, Erin, any comments?
The only comment I have is that Carol and I met with the representatives from the Affordable Housing Committee and Peggy, and decided to have a general community information discussion, session with the Affordable Housing Committee, just to kind of introduce them, talk about how they can be involved with the commission and, the work that they're doing, implementing the Affordable Housing Plan and some, the facts that they've kind of been on a fact-finding mission over this last year since they were formed. And that meeting will also include Ben Fink, who we are utilizing as a facilitator. And he is a consultant through SCROG, who's been assisting several towns in their work to increase conversations about affordable housing and housing diversity in general. And then also we'll include David Fink, who actually is Ben's father, but is sort of the housing guru in the state, who is also a consultant with Scrog. And he'll be able to kind of give a presentation of what affordable housing is, what it means, what it looks like, what some of the fears people have, and just what's happening at a state level as well. So that's the date that seems to work for a lot of parties, and including the consultant, is Thursday, February 29th. It's a hybrid meeting of both in the Hammonasset Room here, which is just next door, and via Zoom. And our consultants are available to join in person. And of course, we would invite all commissioners to be a part of the conversation if you're available. It's really just kind of a community, it really is just a community discussion. It's not any business, you're not selling anything, you're just listening and having an opportunity to.
And to show that
Your
we're
folks.
collaborating with each
Yeah,
other.
yeah, and to meet the members of
I-
the affordable housing. Yeah.
Great idea.
Aaron, are you gonna send an invite out?
Yes, yes. I
Okay, perfect.
was just able to confirm a date with consultants and the
Okay.
Board of Ed's meeting room today, so
Oh, you'll send
That's
it.
great.
yes, I'll send you an invite.
Thank you. Hey, you gonna die or what?
Hopefully not, eventually.
We're almost done, man. Keep it together.
Like,
Not all
Okay,
right.
that's all I have.
All right, anything else? Could I have a motion to adjourn?
Yes, ma'am.
Second?
Second.
Thank you.
Everybody second.
Discussion, all in favor? Great, thank you, everyone.
Good
Thank
night,
you.
everyone.
great.